Donald Trump, the former president of the United States, weighing in outside his home in Florida, Mar-a-Lago. He had been watching the proceedings, seeing his lawyer up against the Colorado lawyer, and he's feeling pretty good, as he should right now. Take a look.
So I just say that in watching the Supreme Court today, I thought it's a very beautiful process. I hope that democracy in this country will continue, because right now we have a very, very tough situation with all of the radical left ideas, with the weaponization of politics. They weaponize it like it's never been weaponized before. It's totally illegal, but they do it anyway. And it has to stop. Every one of the court cases that I'm involved, every single one, civil, whether it's the attorney generals or the district attorneys. You look at Fani in Georgia. They had many meetings with the White House and with the DOJ. They went there, 8-hour meetings. That was all staged. That was a phony hoax. And now you look at it and it is a phony hoax. And hopefully that case will be dismissed in short order. It's a disgrace to this country. But they work together with the Justice Department and the White House, and not supposed to do that. Every one of these cases you see comes out of the White House. It comes out of Biden. It's election interference, and it's really very sad. I thought the presentation today was a very good one. I think it was well received. I hope it was well received. You have millions of people that are out there wanting to vote, and they happen to want to vote for me or the Republican Party, or whatever you want to, however you want to phrase it. But I'm the one running, and we are leading in every poll. We're leading in the local polls, in the state polls, and we're leading in the swing state polls, and we're leading very big in the national polls. So,
wow. So he is alleging here election interference. Listen, after a while, you start to say, come on, guys, come on, enough already, right? I can't believe what I heard today. I just can't believe it, because I'm no legal scholar, okay? I got the business side covered, but I know enough about what I know enough about. I got this little handy Constitution book right by my side. Literally, I keep it on my bedside table. That's some interesting insight for you, right? But anyway, I'm looking at this going, how are they going to possibly go for Colorado, keeping him off the ballot? I mean, it's bonkers. But don't take my word for it. Listen to the Supreme Court justices here. I mean, I have a feeling this may come down unanimously in Donald Trump's favor. I think he's feeling some relief right now. But let's listen. Can we hear first from Elena Kagan, who's talking to the Colorado attorney. Drew, let's cue that one up. I know we're going to listen to Ketanji Brown Jackson as well, because she's like on the wrong case. You know, I think it feels a little helpless there, but we'll get to that. But Elena Kagan first.
There has to be some process for determining those questions. And then the question becomes, does anything in the 14th Amendment say that only Congress can create that process? And Section 5 very clearly is not an exclusive provision. It says Congress shall have power.
But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, you know, this question of whether a former president is disqualified for insurrection to be president.
Wow. Okay, so that's not exactly from somebody who's considered a conservative, right? That's Elena Kagan, you guys. And she's like, you guys kind of have a problem here because Colorado is going to decide everything for the rest of the country. That's not going to fly. I mean, then you got, well, there's so much here. I mean, I want to go to Gorsuch, who just totally, utterly destroys this Colorado attorney. He went to Harvard, I think. We've seen before that Harvard degree doesn't necessarily mean anything. It may not be worth the paper it's printed on when you hear this guy talk. Anyway, let's listen to Justice Gorsuch destroying the Colorado attorney here.
That this court has held. You're not contesting this or asking us to revisit that decision in Thornton or term limits or whatever you want to call it, that it has to come from some federal constitutional authority.
No, we are not, Your Honor.
Okay. And here we're not talking about the qualifications clause. right? Nobody's talking about whether he's 35 years old or natural born, whatever, right? Not at issue, okay? We're talking about something under the 14th Amendment and Section 3. So that's where you have to find your authority, right?
We find our authority in Article 2, in states' plenary power to run their election.
Federal election, but this is for a federal office. It has to come from the Constitution, and you're seeking to enforce Section 3.
We're suggesting that in their broad power to determine them, to select presidential electors in any manner they see fit, they can take account of Section 3 and apply Section 3.
Could they do it without Section 3? Could they disqualify somebody for, on whatever basis they wanted outside of the qualifications clause?
That would run into term limits,
I would think so, right? So it has to come back to Section 3. And if that's true, how does that work, given that Section 3 speaks about holding office, not who may run for office? It was a point Mr. Mitchell was making earlier, and I just wanted to give you a chance to respond to it, because it seems to me that you're asking to enforce in an election context a provision of the Constitution that speaks to holding office. So it's different than the qualifications clause, which is all about who can run and then serve. Yeah.
I don't know that it is different.
Okay.
Other qualifications for office similarly talk about eligibility for the office. There's nothing unconstitutional about a 30-year-old trying to get on the ballot.
Except for this disability can be removed, right, under Section 3. That's what's different about it. So,
Great. This is just great. So, for those of you that don't know what Section 3 is in the 14th Amendment, again, like I said, I got my trusty little book here. Here's my Constitution, and I'm underlining, I'm making notes. I'm looking at Section 2 versus Section 3. So Section 2 is all about sort of, the age, et cetera, right? Like that's sort of like how, whether or not you're qualified if you're going to reach a certain age. But you go to Section 3, and this is what Gorsuch was just referencing. In other words, he's saying that you need to look at Section 3 because this is a federal issue and the states are deriving their power from the federal government. And specifically when it comes to the President of the United States, you've got to look at Section 3. And what's fascinating about this, ladies and gentlemen, is that there is the mention of insurrection in here, but let's go through it. I'm going to actually read it directly from the Constitution itself. This is the 14th Amendment, ratified July 9th, 1868. 14th Amendment, Section 3, no person shall be a senator or representative of Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. All right, so it's saying you can't have done that. But, it goes on to say, Congress may, by a vote of 2/3 of each house, remove such disability. So Gorsuch is making the argument that, by the way, this is sort of in the past. He's not currently holding any office, right? So it doesn't specify. You can't actually say, okay, you're not allowed to run now for something that's in the past. And if you do, well, or you don't, like Congress has that authority. It would actually take 2/3 of the House to override any of this. So this is the point that all of the justices keep on making over and over and over again. And when you look at this particular line there, but Congress maybe, forgive me, go to the line right here. If they've rebellion against the same or given aid or comfort to enemies thereof. Think about that. So if the President of the United States gives aid or comfort to an enemy by way of funding, as in, oh, I don't know, what did we give to Iran? Some $6 billion in that hostage exchange? $6 billion that the Biden administration okayed, gave to Iran along with the hostages. They're trying to say, oh, well, it was their money anyway, whatever. I don't think so. I mean, we can debate those technicalities after the fact. The point is they got $6 billion that they didn't otherwise have, courtesy of the Biden administration. So that's kind of like aid to an enemy. And then the enemy turns around and does what it did. You might actually look at that particular interpretation in a whole new way, maybe against Joe Biden. This is something that Justice Alito points out aggressively to this Colorado attorney. I want to hear this part. Aid and comfort to the enemy.
Thank you.
Thank you, counsel. Justice Thomas? Justice Alito?
And suppose there's a country that proclaims again and again and again that the United States is its biggest enemy, and suppose that the President of the United States, for diplomatic reasons, think that it's in the best interests of the United States to provide funds or release funds so that they can be used by that country. Could a state determine that that person has given aid and comfort to the enemy and therefore keep that person off the ballot?
No, Your Honor. This court has never interpreted the aid and comfort language, which also is present in the.
Okay. I mean, listen, buddy. Jason Murray from Harvard, Colorado guy. You start going there, and you're going to unravel a whole bunch of stuff, which Alito is properly pointing out. He wants to have his cake and eat it too, Mr. Murray does. In other words, he wants one thing. He wants to go after Trump, but he doesn't want anything to apply to Biden. I'm sorry, it doesn't work that way. It doesn't work that way, and I didn't go to law school, okay? By the way, speaking of people that did or did not go to law school, Ketanji Brown Jackson, I'll tell you, she's trying the wrong case here. Listen to this one. This is unbelievable. She's pushing Jonathan Mitchum, who is Donald Trump's lawyer, and she's trying to push him on this insurrection thing. She's like, well, did he not commit an insurrection? And part of Mitchell's point, is that even if he did, it doesn't really matter because you got to get back to Section 3, in which the Congress would have the ability to weigh in on this. Nonetheless, she wants to decide that. And it's like, lady, I'm sorry, but that's another case. Aren't we just deciding Colorado here? Let's watch here or listen to Ketanji Brown Jackson questioning Trump's lawyer.
Compromise provision that was enacted in Section 3.
All right, let me ask you another question about the states, because you have forcefully made an argument about the states not being able to enforce Section 3. So if we agree with you on that, what happens next? I mean, I thought you also wanted us to end the litigation. So is there a possibility that this case continues in federal court if that's our conclusion?
I don't see how it could unless Congress were to enact a statute in response to this court's decision.
So your point is that we would have to say congressional enacting legislation is necessary for either state or federal enforcement?
That's correct.
All right. Final question. The Colorado Supreme Court concluded that the violent attempts of the petitioner's supporters in this case to halt the count on January 6th qualified as an insurrection as defined by Section 3. And I read your opening brief to accept that those events counted as an insurrection, but then your reply seemed to suggest that they were not. So what is your position as to that?
We never accepted or conceded in our opening brief that this was an insurrection. What we said in our opening brief was President Trump did not engage in any act that can plausibly be characterized as insurrection.
All right, so why would this not be an insurrection? What is your argument that it's not? Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So
that's one of many reasons. But for an insurrection, there needs to be an organized, concerted effort to overthrow the government of the United States through violence. And this
so your point is that a chaotic effort to overthrow the government is not an insurrection?
No, we didn't concede that it's an effort to overthrow the government either, Justice Jackson. Right? None of these criteria were met. This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection, as that term is used.
Not to mention that that's not actually what they're even supposed to be talking about. Right? She's still stuck on that. I guess she's got her own political bias weighing in. So maybe it's not going to be unanimous. Maybe Justice Ketanji Brown Jackson is the holdout there because she's got it in her head something. But it's not applicable, right? It just doesn't. And by the way, like if you're gonna say that was an insurrection, don't you run the risk of a whole lot of bias going into anything? Like you could just say anybody, they had a protest outside. That's an insurrection. This is an insurrection. I mean, there's a certain bias that then creeps in, which is what Alito was pointing out when he said, think about the bias of this particular clause. If you've given aid or comfort to the enemies I mean, has the Biden administration not given aid or comfort to the enemies of the United States of America by turning over that $6 billion to Iran? Come on. Like, this is so highly politicized. It's so charged. It's so crazy. It's crazy that we are here in this moment in time dealing with a state like Colorado that's so desperate to take him down that they're now elevating this to the Supreme Court of the United States of America. I go back to everything we've been talking about here on the show, regardless of what you think of the whole ordeal, right? There was a lot of staging going on. In terms of that aftermath, a whole lot of staging. The fact that somehow, some way, the only video that we got to see of the event came from none other than Nancy Pelosi's daughter. Come on, Alexandra Pelosi, the documentary filmmaker, she couldn't call any of her friends at CNN. No, instead, her daughter gave it to CNN or sold it, even worse, to CNN, big family business, I don't know. And suddenly CNN is running clips all over the airways with a big exclusive bug saying CNN exclusive. So duping the American public effectively into thinking that this is somehow journalism, if you can consider CNN independent in any way, shape, or form. I realize that's highly disputable, but you understand where I'm going. So a very packaged narrative sold to the American people, and somehow Donald Trump is now responsible for all of it, and that's going to keep him off the ballot in the state of Colorado, and now it has to waste the time, resources, and effort of our Supreme Court of the United States of America. I'm sorry, it is wild, but I will say this, it's fascinating. I mean, utterly, utterly, utterly fascinating and disturbing that they will go to such lengths to try and keep one person down. I mean, wow, if he's still kicking after this thing, my gosh almighty. Ladies and gentlemen, we have ourselves a winner, right?